Hello, everyone. Welcome back to
Mhm.
another episode of Speaking Legally, where the legal meets the cultural. My name is Dr. Stacey N.C. Grant, and I'm joined by normally my two co-hosts, Royce Russell Esquire and Edward Pichardo Esquire. Ed is on location right now, so he is sending love until he is able to arrive if he can today. But we're still going to have a great show and follow up on some of the information that we shared previously. But we thank you for tuning in. We thank you for joining us 4 p.m. every Wednesday Eastern Standard Time, and the information that we share that impacts you, your family, your knowledge, and your capacity to be able to know who the attorneys are to go to when you need this kind of information. So, welcome to the show, and good afternoon, Mr. Russell. How are you today?
Good afternoon. How are you doing? I hope everything is well with you. And with this cold weather flowing around, it is February, right? And we have
Yeah,
Valentine on the horizon, but I think the heart is going to be frozen. When they see the heart cracking, it usually means love falling apart. It means that it's below freezing point. That's what it really means. So gather your cocoa, catch a seat, and listen to us. That's what we do. Thank you, everybody, for coming in and joining us for another segment of Speaking Legally.
absolutely. Yeah, it has been record temperatures and more snow. I think, at least in the New York, New Jersey area, we seem to be getting all of winter in the month of February. So let's just hope it's fast and quick and we move to spring and March is a nicer weather month. That's the prayer, but we'll see what happens. But nonetheless, we've been talking about a lot. Obviously, the news does not stop reporting the things that go on. Here's where the legal meets the cultural. You've been able to learn and follow along in real time about a lot of the things that we're witnessing. And we started talking about some of the challenges and the impacts of COVID-19 and employment, people who have been furloughed, maybe called back to work, people who are at work. And now jobs are slowly opening up and inviting their members to come back, their employees to come back, and folks are hesitant and they're wondering if they have a way out. And last week we really talked through what that looks like, understanding the law and what work for hire means and what options you really have, because this is new territory and there's a lot that is going to be litigated as a result of COVID-19. And you just need to be armed and prepared with your employer, what your rights are. Have you read your employee handbook? Do you know what things are already in place in writing? And if not, some of the homework that you need to do. So both of our attorneys last week gave you quite a bit of information. And then there's opportunity now to go a little bit further and understand
Mhm.
that if something does come up, and you do get fired or terminated or furloughed, like what does that really mean? So, Mr. Russell, you have some thoughts on that, building on what we shared last week.
Yes, usually after we do a segment, I'll get a flurry of phone calls in a particular area, and last week was no different. And some of the calls that I received were surrounded around actually being terminated or being released. Some people welcome it. Some people knew that it's just part of life, and so I want to have a discussion with our audience today and talk about one aspect of termination and when it's amicable. What does that look like? And what do I mean by amicable termination? That's where you're not fired on the spot. That is not a situation where you caught doing something that was wrong against corporate policies or company policies, but yet the two parties want to move on and they want to come to an agreement on how to move on. And what that is normally called that is called a separation agreement. A lot of people call it a severance agreement, but it's an agreement where parties come together. Either there's a mass layoff, or either one party suggests to the other, employee to employer or employer to employee, that it's time to break. Thank you, thank you, thank you. But it's time to go our separate ways. We turn this two-way street to a one-way street, right? It's almost like when you're traveling in Queens and you got to find out 69th Avenue, 69th Road, and 69th
Hey,
Street.
don't
You
talk
know what I
about
mean?
Queens.
It's just a geographical analogy where one way is a one way, and the ninth and the avenue and the street. So, if you don't know it, you better know it. And so the same thing here with severance and separation agreement. So I just wanted to spend a little time talking about what is that document, and some of the terminology, so it can bring down some of the anxiety and make you better, make you more informed and better informed as to some of the things that you may read when you see a severance agreement. So I'm going to do what they call dive in. So in diving in, first of all, as I said, a separation agreement and a severance agreement is the same thing. Called two separate things, but they are the same document, just with a different title. And basically, it's saying severing, meaning cutting, separation, meaning breaking, agreement between two parties. And usually in this separation agreement, the first thing everyone looks at is the terms of the agreement. How much moolah am I getting to leave? And that circles us back to knowing the employee handbook, because certain companies have certain rules. You've been there for 1 year, you get 1 month of severance. You've been there for 2 years, you get 2 months. Some companies do it by weeks. You've been there 1 year, you get 1 week. You've been there 2 years, you get 2 weeks. Rarely do you find a company that does a year by year calculation of what you're worth. So if you at a company and it's 1 year, 1 week for every year, and you've been there a full, let's say 12 years, you get 12 weeks of severance. If it's 1 month for 1 year and you've been there 12 years, you get 12 months of severance, right? That could be a little disheartening, but that is the reality, because the real is that the company doesn't have to give you anything. They can just say, you know what, we're parting ways. That's it. As we talked about, employees at will, we don't need you anymore. We're moving in a different direction. We'll be more than happy to deal with unemployment payments. And that's that. So the fact that you're getting a severance agreement does not mean, and this is the cultural part, because a lot of people believe within our culture in the African diaspora that because they offer me a severance, that means they did something wrong.
Mm-hmm.
It doesn't mean that. It just means that we're going to pay you to go. We don't mind paying you to go. And here's a little something to go. Doesn't mean that something is wrong. So if you decide not to sign a severance agreement, that doesn't mean that you can call me up and say, all right, I want to sue them, because there may not be nothing to sue. You just didn't sign. You just lost that money. So do not take that as an indication. My people, do not take that as an indication that the employer did something wrong.
So my question, yeah, I catch it. I'm picking up what you're putting down. So you have a choice not to accept the severance agreement, correct?
Right. And so let me start backwards and work my way in, right? And so the back end is that in any severance agreement they will always tell you have 21 days to sign it, and then you have 7 days to revoke it after you sign it. So there's the opportunity, there's your window to say, I signed the agreement because maybe I was pressured, nervous, but I have 7 days to revoke it, or I have 21 days to sign it. So let me call myself, and let me call someone like Brother Pachado, Attorney Abogado Pachado, to the forefront to examine and look at this severance agreement. Now, it doesn't always have to be an attorney. It could be someone you're close confidant, but they better know enough to give enough so you feel comfortable enough that when you take that check will last you enough. You know what I mean? So there's enough there, and there might be enough said on, yes, you do have a right to revoke it. But if we start at the very tip top, when we talk about the compensation, 1 week for every year, 1 month for every year, something of that nature, that usually comes in two forms. That can come in a lump sum, the lump sum payout, and everybody loves the lump sum payout, but I will tell you what's the downfall of that. Or a company could decide to keep you on the payroll for a certain amount of months, right? And what that does is that just keeps their books very clean. That keeps the accounting very clean, the accounting of their payout very clean. And you can expect to receive that check with the normal tax deductions, Social Security, Medicare, whatever your health insurance is, you're going to have all those deductions. So that's why most people run to the table and they say, oh, I want a lump sum. But what they don't realize with the lump sum is that, one, the lump sum might be smaller than what you imagine, because the company still takes out the taxes,
Mhm.
Just because they say they're going to give you 39,000, you think you walking around with 39,000? No, that's not going to happen. Them taxes are coming out because Uncle Sam is really around the corner. And so he has his hammer and his hook, and he's ready to take what he needs to take. Then in other scenarios where they give you a lump sum, they say you're responsible for your taxes. And that's that Monday morning quarterback call we get, Ed, where somebody says, well, I didn't know I was responsible for. Well, you got the lump sum. What do you think?
I mean, what I experienced is the Monday morning was the call
Of course
after
you
about,
did.
oh, this sum is a lot smaller than I thought it was going to be. It can't be right. And then you got to kind of check with, the other side. Well, listen, my guy is saying this isn't right. Could you break it down to me? Could you provide me with more information? Even though you told your client, listen, I think what you want to do is check with your accountant or look at your previous wage statements. They don't want to do that. They're like, oh, I'm being defrauded. They're cheating me and you're not doing anything about it. So you got to, make that call or write that letter. And then you got to break the truth to them that, look, listen, taxes, death and taxes. You got to have that little conversation with them.
That's right.
Nothing is more certain than those. And I'm sorry,
In those conversations, you really want to have up front, right? So if I'm attorney worth my soul, I may charge you an hourly. So get your pen and write this down, ladies and gentlemen. I may charge you hourly, depending upon how much time I think I need to get you to where you want to go. Or I may charge you a flat fee. And so now I'm going to be on the client side, right? Because we often talk about the attorney side. On the client side, what you have to do is look at, is what I'm asking for really, really worth it when I look at my return on my investment? So let me say that one more time. Is what I'm asking for really, really worth it when I look at my return on investment? So therefore, if I'm charging you $1,500, $2,500 flat fee to negotiate your severance package, and you want another week or another 2 months, and that number doesn't equate to more than what you're paying me and after taxes pay, then what are you really doing? All you're doing is fighting for more months just to pay my bill.
So before we continue on that, I just want to shout out, hey DeAndre, good to see you. Hey Rich, thank you for joining in the show, and everybody else who's catching us live on the replay. So just to let you know, what we're talking about today is going further with our conversation about this new climate in COVID and people losing their jobs or, being laid off, or a separation or severance, as Mr. Russell has just started explaining, and understanding what rights do you have? What should you be aware of? What options are there? Do you have to take one when it's presented to you, or you don't? So we're going through that information now because we don't know what the next couple of months are going to bring. Everyone is hopeful that the government can get along long enough to be able to figure out the stimulus that is necessary for businesses to remain open and employ people so that we don't have the financial crisis that everyone is nervous about growing worse. But employment is a big part of it, and how to make sure that you secure your space with your employee. And if it does separate, what does that look like? So, Mr. Pichardo, I know that you had some other pieces you wanted to insert here as well before Mr. Russell continues on this topic.
Well, I'm not sure how much territory you guys were able to cover. I heard my colleague Royce talk about the 21-day window that they give you to sign, and then you have the 7 days to revoke that executed agreement. There's also in there, if you'll notice, in most separation severance packages, some language concerning the various rights you're going to give up, because it's kind of it's a quid pro quo. The employer is trying to free themselves from any possible liability by offering you a lump sum payment. That 7-day revocation language, I'm not sure right now, but that equally applies also to usually the age discrimination claims, because if you look at any of the EEOC guidelines, that's not something that is that employers or employees are free to just waive in one shot. There has to be a period of reflection that the person has before it becomes final in terms of you giving up the right to make such claims. I've always found that the strongest negotiations for these severance agreements is when there exists some sort of issue regarding some inappropriateness in the employer's conduct towards the employee, some possible claims that they want to make sure that they're not going to be vulnerable to in terms of a lawsuit. So they will, up that number on that severance, once you start raising some of that in negotiation. So when clients first contact me about these, I immediately ask them, well, what happened? Why are you getting fired? Have you ever been treated in a discriminatory manner? Is there a discriminatory basis for the termination, or some other issue that we can raise as an incentive for that employer to increase that number? Because usually that number that they are offering can be very bare bottom. Other times it can be quite generous, and so you have to ask the person, "Look, this doesn't look bad to me. You sure?" Sometimes as lawyers we hate to bargain against ourselves in terms of not getting the case, but I think clients definitely appreciate someone who's honest with them and gives them, something, an opinion that they consider fair.
One of the things that you spoke of, Ed, and let me tie it back to returning on investment, and that's where the honesty and sincerity and authenticity comes, right? And so, if you're bargaining for a certain amount, but you're spending way more than that amount, then obviously that is a scenario that you shouldn't move forward. But because you are facing a severance agreement or a separation agreement, that does not automatically mean that somebody's done something wrong. You know what I mean? It doesn't mean that you have a claim. So you could be bargaining and leveraging something that's not really there. So we have to be mindful of that. It might be smoke and mirrors as to what you think you have. And the analysis that you should always think of is, how much money am I spending and how much money am I coming back into my pocket? And for those that missed the segment that we talked about last week, they need to look at that segment last week, because it is about return on investment. It is about mitigating your circumstances. It is about what dollar are you spending and what dollar will you have in your pocket. And as to what you talked about, Ed, in reference to claims, giving up certain rights, the terminology that you usually, because I think it's important for our viewers to understand the terminology that they're going to be faced with, right? So I am methodically going down the terminology that you're going to see. So you will receive something that says release of all claims. That's the quid pro quo. That means I give you $5. That means you give me 5 packs of sunflower seeds. That's the exchange that goes on between a company, an employer, and employee. I'm going to give you the severance package, and you're going to waive any lawsuits that come in the future that you may be a party to. That means somebody may bring a lawsuit and it might be a class action, and you might find yourself, oh, I want to join that, can't join. You may decide that, oh, there was some age discrimination, but if you take this money, that doesn't mean it exists. Just saying, if it comes up, you can't participate. Any Title VII violation, any discriminatory acts, you can't participate because you are taking this money here. That is the exchange, and that's what they call release of claim. And that's why you have that reflection period, the 21-7. And you always see a clause that says, we encourage you to contact your lawyer. That is something that is consult with a lawyer. That's always in every severance package, because they want you to do that.
So we have a question. I'm not sure, Daniel, if you're referring to, said, when is the moratorium in effect till who is covered? Does the rules refer to NYCHA as well? Yes or no? And are there any attorneys that are set up to assisting residents who are bullied through these times?
It sounds to me like the gentleman may be referring to the moratorium on evictions. And
Ed, don't give it away. Danny, stay tuned next week, because that's what's on the table for next week. So you have to make sure you get through this week to get to next week. And I just want to say shout out to Danny B, always in the community, always doing a lot of good things. But we will definitely hit what we call rent abatement and evictions and things of that nature. So just stay tuned. We have a lot of people clamoring about the employer-employee relationship, so we want to get through that model before we get to the next model. But we appreciate your concerns and your statements and your questions. All right,
and it'll still be timely next week as well, because right now this moratorium seems to be in effect.
That's right, and it will stay in effect. So going through some of the other things that we will see when it comes down to severance packages is that we will see something that says that you have to give back the property. You have to return the property. If the company gave you a laptop to do work, it's not your laptop. Cultural. It's not your. Thank you, brother D, brother Dan. It's not cultural. Give back the laptop. If you got a pass to go to the gym and go to the office and you got keys, you got to give those back. Even it's not no boyfriend-girlfriend relationship. I bought that for you. I'm going to keep the ring. No, bro, you got to give it back. And the reason why I make light of it, even though it's something not to truly make light of, is because I've seen situations that become law enforcement related because somebody doesn't want to give a computer back or they don't want to leave the building. It's over. It's done. Especially when you have a severance package that is awaiting for you. You have to see beyond your hands.
And don't expect to be allowed to come upstairs when you return in that equipment. But most of the time, that's going to take place on the first
downstairs
floor
in the lobby.
with the security guard standing there with whoever the HR or tech person, and they're going to ask you for the wire too. It bees that way.
That's right. That's right. And
the charger, I mean, charger, listen, right. You giving us a computer, where's the charger?
And that goes to the point of don't feel disrespected. I mean, we have a number of examples where, I mean, that's where we got the term going postal, right? I mean, I hate to disparage postal workers, but that's where you got the term from, right? You went in and you started shooting up the place. Employers have the right to say, you know what, we fired that guy. That's it. Just give us the cord, give us the computer, and keep it bucking. And make sure you keep your thumb on the road because you're hitchhiking to the next job. And that brings us to the next point, right? So the next point is now you're looking for another job. And what does that mean when you get a severance agreement? Depending upon the industry, you may have a non-compete clause that says you can't work for other employers, and they list those employers because you were in an intellectual property heavy or very, very finite position within the industry. So you can't go out and start your own business to compete against me. And there may be a moratorium where you can't do that. There may be other situations where, let me just explore all the situations, then you can jump in. There may be other situations where you work for a big company. And let's just say you work for Visa, MasterCard. You work for them. And you get terminated from that job. And they give you a severance package. And they pay you this money weekly because you're still on the payroll. Or they're going to give you a lump sum bi-monthly or what have you. What some of those packages will say is that, but if you find a job within our company, because you're terminated from this sector, you can still find a job within the company because the company is very big. Then you can't do what I call a double dip. And the double dip is that you're getting your severance and you're working again. A lot of agreements don't allow that. Do people still do it? Hell yes. As long as the sun comes out in the morning and the day is long and it's 12 o'clock 2 times in a day, yes, definitely. However, you may have an agreement that says that you can't double dip. Sometimes agreements don't say that. That means you can find a job while you're still getting paid your severance, and therefore, hallelujah, you're double dipping. But some cases, they won't allow you to double dip. And they expect you to have good faith intention that if you find another job, that you let them know so they can stop paying out. And that is very, 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 very important.
Yeah, that's why it's very important to, yes, you get your attorney. Yes, you have that person take a look at that agreement, but you definitely should make sure that you read all those provisions yourself and ask questions and understand what each of those mean. With respect to those non-compete agreements, there are certain agreements that if they contain certain provisions, depending on the industry, they can be considered unconscionable or unenforceable. Actually, I recently had to do some commentary on one of these, and one of the things that becomes clear in the case law, or rather the many judges' decisions, is that the law doesn't necessarily favor these in many cases because, you know, we are living in a capitalist country, and generally people should be free to pursue whatever means that are within their talents economically that can, you know, help support themselves. And so these non-compete agreements can't be set up in such a way where they prevent you from earning an income. So many times, you know, Royce and I will look at, well, what is the mileage on this thing? What do I be my mileage, the geographical area application of the agreement? Is it within the Metro New York City area? Is it multi-state? Is it the entire country? Is it the world? You know, so if you get my point, at some point, you know, the agreement may, you know, just may be too overbroad is what we would classify such an agreement. In terms of competition in industry, what kind of jobs, what kind of businesses, that also can't be too broad. They're also going to look at, you know, were you a high earner in this company, highly placed, privy to what's called proprietary information, like some really unique information that only a few people are aware of in this industry that makes you somebody that employer really should fear will prevent them from, you know, doing what they have to do, because they will argue, listen, we invested in this person, and they have to clearly show a business necessity for the provisions in the non-compete agreement. And, you know, in many cases, they will argue that they engaged in a certain amount of investment in you as an employee prior to the termination / resignation. You know, you also have to look at what the time period for it is. Is it a year? Is it 2 years? You may find multiple years within that agreement to apply to certain levels of competition. You can't open up another, you can't go to another similar employer within a year, but, you know, the clause having to do with opening up the same business maybe 2 years. So, you know, these agreements, you know, we look at them very closely to see, you know, if they're actually enforceable, and, you know, and whatever opinion we give on it is limited by it being what we would call sometimes preemptive. Like, we can give you an opinion on the enforceability of this, but we will never ever really be able to truly know what the outcome will be on this agreement, unless, of course, they claim that you breached it, and then they decide to try to enforce it in court, and you have to, you know, fight.
One of the things that we understand with this is that this is not being done for free, right? So Absolutely. You are getting compensated, right? Mm-hmm. You know, not the attorneys, the employee is mm-hmm. getting compensated. So you say, hey, oh my God, what do you mean non-compete? Yeah, but you're getting paid, right? And you're getting paid at the salary that you were if you were at the other job. So therefore, how much ruffling of the feathers can there be? And as you said, we're only as good as the agreement is before us, and whether there is latitude to change some things. Go ahead, Ed.
And just to be clear, that part about you getting paid for this in contract law, we call that consideration. You're getting something in return for something that you're agreeing to, and that's also something that courts will look at in terms of the enforceability of it. And just one little small added point that I wanted to make, because Royce said something that just, you know, blazed through my mind. It turned on a light, quite frankly, and that is, make sure that you be careful in terms of contemplating your breach of this agreement. What do I mean? You decide to apply for another position in the company, you're not supposed to. You decide to apply for another job and not inform these people, and there's a clear provision after this. You have to make sure that there's not a clawback associated with that. What do I mean by clawback? Having to pay back that money that was given to you prior.
All of it.
All of it. Ahí sí.
Ahí
sí. Ahora sí que te va a joder. Va a tener que pagar todo ese dinero. You're not going to like that. You're not going to like that at all.
That's
you're
right.
You're going to be calling me, mira lo que me están haciendo. They want me to pay all this money back. And I'm like, yo, what did you do?
And I don't know what you said, but it sounds like what you said is like, oh my God, I got to pay this money back, bro. How can I get around it?
I spent it already.
That's right.
I spent it already. I was at the Malecón.
I gave some. I gave some.
I went to Cancun. I bought my girl a fur coat. She's not gonna let me take that back.
No,
what's going on? Nah,
no,
what happens if you can't pay it back?
Well, you get a judgment against you like anything else that you can't do in life. You get that lien on you.
Yeah. That check looking small and stuff.
Right. God is those payments.
They sent the judgment to the payroll department on you.
I think, hold on 1 second. I think Stacy had a question. Hey, Stacy, thanks for tuning in. She said there are situations where the non-compete won't fly. Can't work for 2 years within 5 flying miles or 3 different locations. I think that you answered some of it. She said, thank you, but that was a good question.
Yeah, like I said earlier, we gotta look at the specific terms and the industry to see if that's even enforceable or not. So you're gonna get very industry specific questions. Well, how many other airline companies fly to those cities, to those locations? What particular proprietary knowledge do you have that they can claim as a business necessity for preventing you within a certain period of time from working for another company doing what you were doing for them?
So I think the difference is that, look, if you're a staff employee, mid-management, and you work for Chase, no. You non-compete. You can go work for, Wells Fargo. You can go work for, HSB, whatever the bank is. But if you work for a Cake Man Raven and we cooking up the cakes in the back, and I'm showing you this the Cake Man Raven secret of how to make the best cake out here in New York City. Shout out to my man, Brother Raven, the best cake out in the state of New York, and it's in some other states. And then you think you're going to bounce over to Bake My Cake, or you think you're going to bounce over and open your own shop? No, we put non-competes all up and down, sideways, left, right, intellectual property. We're not going to let you take that. But one of the other clauses that come into play when you leave that computer downstairs and the charger and you're told not to compete is the non-disparaging clause. And what do we mean by the non-disparage? It's exactly what it says. Is that usually when people get fired, terminate, whether they leave amicably or not, they want to disparage their employer. Just like you in a relationship, it was her fault or it was his fault. Nobody's taking the real blame like, yeah, man, I was 80%, she was 20%, or it was 50-50. It was no, they got the 80, I got the 20, right? And so, now I see them on post, somebody said they want cake. I hear you.
I want cake too.
You know what I'm saying? I do too. But it's always someone else's fault. So you can't disparage. So what they have is a non-disparage clause. What I call it the no potty mouth. You can't have potty mouth, right? You can't go around cursing your employer, using foul language. You gotta get your soap, you gotta wash your mouth. But in what I call the no potty mouth clause, that needs to be reciprocal. And a lot of employees, and they don't know that. Like when I speak to people about severance package, they're all ready to sign off on that. I can't disparage. I can't have potty mouth when it comes down to my employer. I can't say how bad my employer is. But they fail to realize that nowhere in the contract does it say that the employer can't badmouth you. So that needs to be in there because they can have potty mouth when it comes to you. They can say, oh yeah, Mr. Russell was a bad employee. He did A, B, and C. He was never on time, just because they want to damage your career. So there needs to be reciprocal clauses in that. And there also needs to be a letter of neutrality And what I mean by that is that the company is forbidden to say anything but for Mr. Russell worked for us for 5 years in this capacity. Point blank. 5 years, 4 years, 3 years in this capacity. Or they outsource it to a company that when someone calls for a referral and your name come up, Dr. Grant comes up, it automatically goes to the outsourced company. And the outsourced company says, Dr. Grant worked for this Destiny Design University from April to May, and that was it. You know, from 5 years, 7 years. So we have to make sure that the potty mouth clause goes both ways. We got to make sure that either is outsourced or somehow is red flag, because, you know, we got all these conspiracy theories, some of it true, some of it not. I went to go get another job and I know my employer stopped me. Well, one, I don't, you know, you shouldn't have gave your employer, your past employer as a reference. But two, if that type of due diligence is going on and you don't have that non-disparage, no potty mouth clause in there, then you got a problem. And that's why you need sometimes to consult with an attorney to make sure that those things are in there.
Yeah, I mean, you know, sometimes, you know, depending on the action, you know, it can be hard to prove because, you know, in the real world, a lot of times we know that a lot of the discussions take place in private outside of official channels. And, you know, somebody you know, if you list that employer as a reference and you're talking about a high level position in, you know, in small circles, people are going to say, hey, we interviewed so-and-so the other day. I believe they worked over there for you. Anything to say? And if that person is dead silent, I really wish not to talk about it. It's like, oh.
That's saying something.
Like, yeah, that's that loud enough. Silence, right?
That's saying enough.
Like,
that's saying enough.
Yeah.
That's definitely saying enough. So sometimes inaction can speak louder than actions, right? Mm-hmm. Non-verbal communication can speak louder than verbal communication. And I get that, but no document is foolproof, right? We're not going to be able to have a document. And even if a document is foolproof, how you implement it and how you catch those that might be violating the document is almost impossible. Mm-hmm. Almost impossible.
So, I mean, this is definitely good information once again, where the legal meets the cultural. Like, how do you deal with all of these impacts that we're talking about with the unknown? Because a lot of this as well with what will happen with law and the impacts and what happens in the court as you litigate around these things, you know, it really makes it important for you to know ahead of time how you're going to approach these things, to even know to talk to an attorney about what protects you in a separation agreement, you know, that you have that wherewithal. If that's not your wheelhouse of brilliance, why would you sign off on something that you haven't gotten a professional consultation on by a licensed attorney who can help you navigate what's going on? And I know there's some other parts to that you want to cover. And then I want to hit some of these other areas, you know, about paid sick leave, unemployment benefits. These are all the things that are happening in real time, and we don't know how the COVID implications are going to affect those in our community.
Well, let me just run through 3 more concepts, and then Ed could pick up on, you know, unemployment and how these things affect it. I'm going to start at a place that you just left off. You said sick, right? And so when we look at severance agreements, there are provisions that speak to that if we're going to keep you on the payroll, you still have the health insurance. If we give you a lump sum, you still have the same health insurance for a period of time. Once you get off the payroll, and once we pay you for whatever time and service, then you might have to fall back on COBRA. I wish I could remember the acronym. Somebody out there, why don't you type that up for us, what the acronym of COBRA is? But basically, it is healthcare alternative, where you have to now pay for your healthcare. You can keep the same healthcare, but you have to pay a higher portion of it. Or now you have the right to go to COBRA and you can manage what your health care is. The company still is not going to pay for it as if you are an employee that you once were last week. So that becomes an issue, right? And sometimes companies give what they call outplace services. That means they will help you get another job. You can come back to the company, they'll work on your resume, or they'll put you in contact with a company that will help you with your resume, will help you with transitioning into another career, transitioning to another company. And let me just say, COBRA and outsourcing for outplacement, other job opportunities have value as an attorney and has value to the employee. It has value because now you have someone that's working with your resume. Don't be mad and say, "Oh, well, you don't want to hire me. You fired me, so I don't want anything to do with you." So Fordham University U. Just understand what Fordham University stands for. If you put just the F in the U, Fordham University U, because we have a severance agreement, and so I'm not going to take the placement services. One, that may not be smart. Two, Fordham University U, because you put me on COBRA and I don't want the healthcare. Matter of fact, what I would say, and I say to many of my clients, is let's think about it differently. How much is the outplacement worth? I say that to the employer. What is that number? That is $5,000. That's $6,000. That's $7,000. That's $10,000. Well, my client really doesn't want that service. Why don't we change that number that you were going to put out there for that service, $10,000, $15,000? Let's add that to the compensation. My client happens to be in a household where their healthcare is going to be okay, but you're providing healthcare. Let's take that $10,000, $20,000. Let's put that onto their compensation. Let's put that onto their compensation. You know what I mean? That's where the negotiation and the leverage and reaching out to an attorney and not taking a standpoint of, Fordham University U because you terminated me or because there is a severance agreement. Use what's there to raise the compensation and raise your package. And that is some of the things that corporations will do. And before we get to unemployment, let me just speak quickly to severability. You'll see that a lot in these documents. It's called severability. What does that mean? That means, hey, you catch me before I catch you. And just because you caught me don't mean that it's all over. And what do I mean by that? If there is one clause in the whole contract, that doesn't mean the whole contract is bad. It's the one bad apple theory. One bad apple don't spoil a whole bunch of girls, right? If there is something that is wrong, clause A in the contract, that doesn't mean B, C, D, E, F, and G goes away. It just means A goes away. I would sing One Bad Apple, but I'll leave that for another time, another audition. But that's what we call one bad apple don't spoil a whole bunch of, it just doesn't. So don't think, oh, we got them on one side and so it's all over. That doesn't happen. And what is also important is who rules, right? It's Rick the Ruler rule. That's what I call it, Rick the Ruler. Who rules? Who do you go to when there is a disagreement about the severance agreement? Are you forced to go to court? Are you forced to go to arbitration? Who decides whether you go to arbitration or court? Will you be held by the standards of the law in New York, even though the headquarters of the corporation is in Ohio and there's a subsidiary in New York? Those are the things you have to look at that you may want to leverage because you know the laws where you live, not the laws in Ohio or Pennsylvania. So there you go. Severance package, okay. Separation agreement 101-444.
Yes, and the Fordham University, clearly you love Fordham University.
Clearly, it comes in handy.
So, Senor Pichardo, when we talk about these COVID impacts and not knowing what to do, and if you do get sick, like what's happening, what's the trend? Like, what if you do contract COVID and you're not able to come to work for an extended period of time because the virus has all of these different strands and mutations and variants, and, people are having side effects, after effects, they even named some of those who are still dealing. What say you on what people need to be aware of legally to protect themselves in this time?
Well, clearly, if you contract COVID, you're suffering from an illness, you're sick, you're definitely entitled to sick leave as long as you haven't exhausted that sick leave. There's a certain amount of sick leave that you're going to be entitled to, no matter what, I believe, depending on the size of the employer. I haven't dealt with that in a while in terms of the paid sick leave law that passed here in New York City. But certainly, what you want to definitely do is get the documentation together so there's no question as to whether or not, that sick leave is legitimate. You don't want to get caught in a situation where you're missing work and you're considered away without leave and subject to termination or accused of some sort of misconduct. And then, I think we talked about it at the last show. Even after you exhaust your sick leave, you still would be entitled to some family medical leave nonetheless. However, that's unpaid, unfortunately. That doesn't do much for the pockets, but at least gives you some relief in terms of not having to be able or not having to be at work or reporting for work, even if you work from home. So that's what I would have to say about that. In terms of the unemployment insurance benefits, we alluded to this quite a bit the last show. Unemployment insurance, you are entitled to it under most circumstances if you've been laid off and you haven't done anything to be responsible for your own termination or resignation. In some cases, you can't resign from a job and then turn around and say, well, I want to collect unemployment. That's a no-no. We talked about mitigation. One of the things you have to make sure that you understand with the unemployment is that you still have to look for a job. You still have to be ready to work. Now, that's a bit of a catch-22 right there, right?
Yeah, right.
If you are sick, let's say you're sick, and you say, well, I want to collect unemployment, you really can't collect unemployment because you're not actually ready to work. Okay, so you're not necessarily entitled to unemployment. So that's where that catch-22 can come in. In some cases, this may manifest itself where you say you suffer an injury of some sort that doesn't allow you to be completely fit for duty for the type of job that you have. However, you are physically able to perform maybe other functions, not necessarily the one that you are in. And so what you would ask the employer to do is to offer you, quote unquote, a reasonable accommodation. Let's say I'm a haul or I have a heavy lifting job, and you say, well, listen, how about I'm the guy who puts the tags on the boxes? That's less strenuous. I can do that within my limitations. I am ready to work. In those circumstances, if the employer doesn't have an accommodation to offer you, but there are positions at the company and you're ready to work, you can make the case that you are entitled to those benefits. And if the employer denies those benefits, says, no way, we're not paying, we object, because what happens is when you put in your claim with unemployment, which is the state, New York State, if you're working in New York State, the job is in New York State, you apply for unemployment to New York State. What happens is that if the state will contact the employer, they will say, Ed Pichardo is applying for unemployment. What say you? Are you okay with that? Do you object in any way? If the employer objects, there is a way to fight the employer, meaning to contest what the employer's denial. And so what you would do is you would file what's called an appeal, and that will go before an administrative law judge. And, it can take the form of, they will ask you for a statement. They will ask the employer for a statement. They will try to maybe figure out a way to see if, someone budges. But if, neither side budges, then you will actually have a hearing before an administrative law judge. That administrative law judge will hear what you have to say, will hear what the company's representative has to say, and then make a determination as to whether or not you're entitled to unemployment. And even that decision.
Can I interject? Can I interject one thing? I just want to make sure people understand the things that Abogado Pachado is talking about takes time.
Yes,
I mean,
absolutely.
like, I want to let you know it takes time. Now you're talking about doing these things online or over the phone, filing your application for unemployment, on the phone, having an officer call you back on the phone, having the officer call the employer on the phone, have the employer make the phone call back. It may not be the same day. The employer, see what folks need to understand when it comes down to unemployment, the employer contributes to it. So if the employer is contributing to it, they may have something to say as to why not they don't want to pay you that. That's why a lot of it is contested, because it's like we have to contribute to it. So all of that takes time. The hearing happens over the phone. It may happen with a judge that's up in Albany. I mean, all of this takes time, and you need to be aware of that. And so if it takes time, you need to be on point with your documentation to hopefully speed up the process. I'm sorry, I continue.
Yeah, no. You're absolutely right. I had a gentleman who suffered for months, had been waiting for, his hearing before unemployment. Finally, it happened. Finally, we were able to get him his money, but, he had to wait. It's a testament to the rainy day fund and people living either beyond their means or having no savings. You gotta save for that rainy day no matter what. I mean, I think many of us, given, our ages, maybe you guys are a little younger than me, we know several, our parents and other members of their family who went through the Great Depression and know the power of saving $1. And that's what, we're talking about, not taking any chances, not living paycheck to paycheck. You got to be able to have some sustenance for the fight. And you probably are going to have to wait for that day when you get hurt and finally that, money comes in. But, I'm kind of giving the audience out there, the tools in terms of, fighting this, because I've had folks come to me thinking it's helpless. Oh, they deny me my unemployment. I don't know what to do. And I'm like, nah, you got plenty what you could do. You just got to be able to, stand up for the fight. Where your paperwork at, like Roy said? Where's your stuff at?
And that's why the show is where the legal meets the cultural, so that we can let people know what to do, be prepared for the long haul. There's no, get it overnight, because that's just not how the system works with most things, no matter what area of law you're talking about. So we appreciate this insight, and hopefully it helps those of you that are listening in that might be in the situation, or you might know somebody in the situation. The moral to the story: make sure that you go to an attorney that's knowledgeable, like Mr. Russell or Mr. Pichardo, so that they can give you the correct advice and be able to really review and understand what's in writing. That's a big challenge with us looking and reading. You need to know what it is that you have and what you can use on your side to make sure that whatever the outcome, it's the best outcome possible that it could be. And I know that we're nearing the top of the hour. I want to let Mr. Pichardo finish his point on this. And then, of course, we have to end out with current events. I mean, clearly, we would be tone deaf if we didn't touch on the fact that we know what's happening at our nation's headquarters on this case. And I know that, Mr. Pichardo, you like to follow the politics of it all. And as we close out, just some quick thoughts on where you think this particular case is headed. Are they going to convict, or is this just going to be an exercise in futility?
We're talking about the impeachment.
Get your treadmill out. Get your treadmill out. Get your treadmill. Get your treadmill out. Exercise in futility.
I mean, listen, who knows? I mean, there were some very moving discourses by some of the impeachment managers. I believe Congressman Raskin, he got very emotional yesterday about how his son, I believe, had committed suicide a few days before Jan 6, and how he had his family, at the Congress the day that it occurred, and somehow they got separated when he was told to put on a mask and removed from the floor, and he got, obviously emotional about that. And the hope is that, some of these folks on the other side have a heart and decide, you know what, I'm I'm going to have some courage and I'm going to stand up. I mean, it's refreshing to know that I believe it was 16 of those Republican senators voted to at least have a trial. Okay. And hopefully, some more will join them, because I believe it has to be a 2/3 vote in order for them to convict. And the object right now is not removal, but he's gone, but to disqualify him from holding office in the future, because he made some very clear pronouncement that he's looking to get that office. I hope that some of these Republicans realize that they were in danger. In fact, those folks that invaded the Capitol were after Vice President Pence. They were like down with Pence. If they would have caught that man in the hallway, I don't think his hair would have remained white. I think it would have started red. I mean, I remember that on his head that time of the debate.
To your point, people are forecasting their future, and they hanging their hat with this guy, right? But what it does for many is that it helps pull the sheet from off of the head, and so you can see the real face. And so even though this might be an exercise in fertility in that, or futility in that, nothing's going to come out of it, because I think the sway is too heavy. The sway is just too big of a number. You get a chance to remove those sheets off of people's faces. You'll be able to see the true colors, as they say, true colors shining through. You'll be able to see that and see where they stand, because now is no longer him being in office, so you have to walk in line with him. It's no longer an issue of where do we stand as Republicans, because you're split as a party. This is your individual choice. It's not about your constituents. This is your individual choice to say, look, hand down, man down, not getting my vote.
Well, hope springs eternal, right? That's what we always say. This is a crossroads in history. A lot has happened. A lot will continue to happen. It definitely gives us pause when we think about how we can rationalize things that are right in front of our eyes. Like I continue to be baffled by how we can see the world through such different lenses. I know everyone has a different paradigm, but the last time I checked, the truth is the truth, no matter what. But clearly, there's some variations that are existing in our world. So
no, it's not an issue with the truth being the truth. The issue is when you got to vote on the truth, you turn around, because the facts are not changing. We just not voting on that. We just like, you know what? I abstain.
Yeah, I mean, it's amazing how that word truth has now become a buzzword having multiple meanings. I mean, it used to be that when you talked about the truth, it wasn't ambiguous. It wasn't subject to different interpretations.
Now you hear that famous term, my truth is.
My truth is. I don't know what your truth is, but my truth is. I mean,
yeah, really? No, the truth. How about the truth? It ain't your truth. It's the truth.
Oh man, it's amazing, but we're gonna see. I mean, it's amazing. I mean, my understanding is that the first set of lawyers that he was trying to retain, he wanted them to continue to push the election fraud took place theory, and they said no, we're not doing that, because at some point you have to separate yourself from the client when the client wants you to make arguments that are either frivolous or just completely out of this world. And it's refreshing to see at least some of these lawyers say, I don't care how much money you're offering me. But then a second set of lawyers, because I guess you can always find a few.
No, wait. And let me put that back in the box. It has nothing to do with the profession of lawyers. You can always find somebody that will take on any task.
Yeah, that's true.
Any amount of money, no matter what. You can get your car fixed for $5. You can, but you have a $5 fixed car. You can get your hair cut. You get your hair cut for $2.
What you pay for.
So that's it. So
It's
you
true,
know,
man.
Yeah,
I remember
but
one
it's
time
true.
my man got his car painted, and it looked like they just used some spray can pans on the joint. It was looking crazy.
Oh my
Anyway,
God. This is where the legal meets the cultural, clearly. But we thank you all for tuning in. Richard, we appreciate you. DeAndre, Daniel, Stacy, Michael, thank you for tuning in. Kevin, always great to see you. I was cracking up looking at Kevin's comments. Some folks live in an echo chamber. That's so true, my brother.
yeah.
Well, what we will keep doing on this show is making sure that you know you have two legal experts that are accessible and that are credible and that are experts in what they've been litigating for over 20 years. So this is not, they didn't just show up yesterday on the sidewalk trying to tell you what to do in the areas that they specialize. So make sure you reach out to them. You have the websites there for cardiac arrest book. Just having that as a tactical guide is important. But the law office of EdwardPichardo.com, RoyceRussellEsquire.com. Make sure you have them just on somewhere on your refrigerator. Hold a note, save the show, because you want to be able to have someone that you can call before the emergency happens. All right,
Ed, I want to know how can you be practicing law for 28 years and you only 27? How you do that, Ed?
I was 1 years old when I decided. Nah.
All right, family. Have a good one. We'll see you same time, same place next week, 4 p.m. Eastern Standard Time. Bye bye. Stay safe and be well.